Greetings, friends of liberty. When we look to the origins of any belief system based on self-deception, be it religious or secular, 'tis remarkable how often we find the hand of the state, that is the use of violence and coercion, employed. So, during the Christianization of the Anglo-Saxons, we see that as early as 597, Pope Gregory the Great sent a mission to Kent, which converted King Ethelbert, who then forced two other kings, Ratswald and Siebert of East Anglia and Essex, to convert as well. And by 640 in Kent, pagan practices were simply outlawed, with pagans fined or executed depending on their alleged crime. The next king of Kent, Eorsenbert, decreed that all pagan statues should be demolished and certain Christian holidays observed on pain of punishment. Understandably, since what pagan-loving meat would want to voluntarily fast through the 40 days of Lent? The Christians, along with the Muslims, who themselves fast during Ramadan, all think that not eating somehow makes them more holy. No, just more hungry. Now, if we turn from the issue of the origins of religious belief, like Christianity, to that of secular belief, your own 21st century in America, we find today the powerful arguments and insights of Richard Hanania in his The Origins of Woke, Civil Rights Law, Corporate America, and the Triumph of Identity Politics. In his work, Hanania, one of the rare classical liberals to tackle the subject in book form, distinguishes himself by employing a radically different interpretive principle than the vast majority of anti-woke authors. As Hanania says, what I found strange was the extent to which woke beliefs and practices were mandated by law. What law? Civil rights law, and more specifically, the anti-discrimination portions of the Civil Rights Acts of 1964 and 91. Could these, and their subsequent implementation, really be the primary or only real cause of woke? To make sure we all start on the same page, Hanania defines his terms. Woke, he says, has three attributes. 1, the belief that disparities equal discrimination. 2, speech needs to be restricted. And 3, in the interest of overcoming disparities and regulating speech, a full-time bureaucracy is needed. Having set the stage, he turns to the passage of the Civil Rights Act of 1964. In dispute in congressional hearings and debates for passage was not whether equal access to public accommodation should be allowed blacks, as became protected by Title II, or whether their voting rights should be protected in full, as was protected by Title I, but instead whether businesses or other institutions should be policed for whether they engaged in racial discrimination. In this regard, leading Democratic Senator Hubert Humphrey argued that nothing contained in the Civil Rights Act shall be interpreted to require any employer or labor union to grant preferential treatment to any individual or to any group because of the race, color, religion, sex, or national origin of such individual. In other words, neither reverse racism nor quotas would be allowed. Senator Humphrey explicitly said, "I will eat my hat if this leads to racial quotas." And so on these assurances, after lengthy debate, the Civil Rights Act of 1964 was passed. Immediately thereafter, a government agency was created to enforce it called the Equal Employment Opportunity Commission, the EEOC, in order to examine whether employers had racially discriminated against job candidates. It and other agencies felt the need to collect statistics, lots of statistics, and so began an extensive effort to record the race, color, and some national origins of just about every student, employee, and recipient of government benefits or services in the nation. Now, it was not surprising, given that the Civil Rights Act had obviously implied that using IQ or other intelligence tests on job candidates was perfectly allowable, that Duke Power Company in North Carolina did just that. And yet, a suit was soon brought against them in 1971 for this very practice. the Supreme Court unfortunately complying with the absurd advice of the EEOC, who claimed that anything which had a disparate impact on blacks shouldn't be allowed because it was against the spirit of the Civil Rights Act, decided against Duke power. The court thereby incentivized any business doing anything which had some unequal or disparate impact on blacks to be sued for anything. Hanania notes here, as others such as legal scholar Gail Harriet have done, that there will always be disparate impacts to any policy. Ms. Harriet, in fact, has offered to donate $10,000 to the charity of choice of anyone who can find a single employment criterion that does not have a disparate impact on some group. She hasn't had to pay up. That's because, just like individuals, all groups, whether racial, sexual, national, or otherwise, are unique and will always test differently. But how do the EEOC and the courts decide what is an actual disparate impact? By applying quotas, using all those stats they made businesses collect. As Hanania says, nowadays, the business must record the number of males and females of each of the following groups: blacks, Hispanics, Asians, Pacific Islanders, and American Indians, Alaskan Natives. Then, for example, the EEOC can show that while blacks make up 40% of your city, they only make up 9% of a company's workforce, even though the company's a STEM company and blacks make up only 9% of STEM fields. And so the black who wasn't hired and who sues can get a huge payout because that company should have 40% blacks. Which leads one to wonder, did Senator Humphrey, who promised to eat his hat if quotas came, ever make a meal of it? Now, one further subtlety is that since quotas are obviously outlawed by the Civil Rights Act, the EEOC can't and doesn't legally order the business to hire according to quotas. It just punishes them if they don't. As Hanania summarizes from the business's perspective, all they can know for certain is that they must go through the motions and that hiring and promoting more minorities and women will be less likely to get them in trouble. This, of course, is called affirmative action, another euphemism, and means unjustly privileging one group over another on various employment or admissions criterion, which is a typical result of this governmentally enforced bigotry. What is? States and localities hiring police, firefighters, and correctional officers who are now forced to lower physical standards in order to be able to hire more women. Speech, too, has necessarily been restricted because it might hurt the feelings of a protected class, namely women. This restriction appears unconstitutional, a violation of the First Amendment, but do you think the Supreme Court would ever have dared to rule the Civil Rights Act unconstitutional? Other judicial innovations followed. Sexual harassment cases could be filed as class actions. Employers could be held responsible for the actions of their employees, not just themselves. And offensive language and pornography can constitute a hostile workplace, even if not targeted at any particular employee. What all these and other legal fictions create is a radical depersonalization of the American workplace with little flirting, jokes, or real conviviality allowed. Dialogue becomes scripted and artificial, anodyne. Let's now turn to another portion of the Civil Rights Act, Title IX, whose enormous harms I covered in great detail in my review of Jessica Gavora's Tilting the Playing Field. Title IX initially was added to outlaw irrational discrimination against females in sports and on the job, just like Congress, in its naivete, thought it could do in attacking racism. But just as those other anti-racist statutes actually turned into engines of discrimination against whites and Asians, this too occurred against males with Title IX. Regarding college sports, it mandated equal numbers of female and male teams, even though males like playing and watching sports much more than females. As a result, hundreds, if not thousands of male American college teams in wrestling, baseball, and other sports have simply been eliminated. Not surprisingly as well, the frequency of total lawsuits radically increased. In the mid-1970s, there were only about 5,000 EEOC charges of discrimination a year. By 2010, there were close to 100,000 a 20-fold increase. The lawsuits are often very rewarding with high punitive damages. Bank of America, for example, paying hundreds of millions of dollars over the last 2 decades, which costs are just passed on to consumers. Quite necessarily, all this regulation and oversight, in order to discriminate against males, non-blacks, and the healthy, has resulted in a huge growth of federal bureaucracies, college administrations, and HR departments within businesses. As Hanania says, Yale currently has about as many administrators and managers as it does students. Similarly, in 1968, only 1 in 558 American workers were employed in human resources. By 2021, that number had risen to 1 in 102, a 5-fold increase. At this point, Hanania stresses his central thesis that 2 of the central tenets of wokeness, disparities are caused by discrimination, and speech must be restricted, are not listed as official state doctrine in any legal textbook. Instead, he argues that they've blossomed in the universities and the wider culture precisely because they've been first practiced by the government on others, after which, he argues, the ideology emerged. Similarly, he argues at length that the artificial creation by the government of certain ethnicities out of thin air, like Hispanic, Asian American, and Pacific Islander, has also correspondingly created an artificial ethnic awareness among these subgroups. In his next section, he proceeds to a very detailed history of the various Republican administrations since the 1964 Civil Rights Act, noting that the Republicans, who theoretically should be more able to oppose anti-discrimination law, since 2000 alone have had unified control of government in 3 Congresses, 108th, 109th, and 115th, and parts of a 4th, 107th. But Republicans in power have only made at best marginal changes to the status quo. At worst, as during the administrations of Nixon and the elder Bush, they have pushed the civil rights regime further than their Democratic predecessors had. Excuse me. Trump's first term he describes as pushing back in areas like Title IX sexual assault tribunals, overturning the previous administration's push to mandate gender theory in the nation's schools, investigating colleges for anti-white discrimination, scaling back EEOC enforcement, and near the end, clamping down on critical race theory trainings in the federal government. He argues that the present climate is conducive to reversing the anti-discrimination statutes, since, number 1, Republicans are obviously now an anti-woke party. Number 2, as he correctly observes, mass opinion is overwhelmingly against quotas. And 3, because of the polarization of the right and left. The previous Republican moderates, who had often collaborated with the Democrats in resisting change, are now gone. And so he suggests, thankfully, there is low-hanging fruit in the policy space, actions that can be taken through the executive branch or judiciary. What solutions does he offer to potentially extricate America from its woke quagmire? Number 1, amending Executive Order 11246 can be done on the first day of Republican administration. President Trump, in fact, revoked this on January 21st, perhaps following Richard's suggestion. This order had been used by the Department of Labor's Office of Federal Contract Compliance Programs to specifically privilege minorities in giving them federal contracts over everyone else. Number 2, the Supreme Court can throw out disparate impact as a violation of the Equal Protection Clause the moment it gets the right case. And 3, harassment law likewise rests on shaky constitutional grounds. The regulation of sex in sports under Title IX resembles disparate impact in that it is the result of bureaucratic and judicial innovations that have little resemblance to the original intent of the statute. So now, having seen at length his own approach, let's evaluate the intellectual framework he employs to understand the origins of woke. Number 1, we start with Richard's belief that law can create culture. He here specifically meaning that civil rights law created woke culture. As he says, if it seems that our culture has built an elaborate ranking system of races, genders, and traumas, it is because our legal system did it first. The only problem with this formulation is that it immediately leads to the following question. If presumably bad law creates bad culture, what is bad law? I would suggest that rights-violating law creates bad culture and rights-respecting or preserving law, good culture. Number 2. Now, if this is true, it means that any potentially rights-violating law might be a contributor to the rise of woke, and thus we want to figure out which rights-violating laws might be causally relevant. Number 3, this brings us to the relevance of public education, which, using the taxing power of the state unjustly, and also receiving numerous tax exemptions on property and capital gains tax and others, is a violation of the civil rights of parents and children to educate themselves the way they choose. It's the opposite of school choice, it's school coercion and indoctrination by the state in woke ideas, as we've seen. Couldn't this be relevant? Well, if we look at some American colleges that are truly private and getting little or no money from the state, like Hillsdale and Grove City colleges, these are not woke at all. Secondly, if we look at the history of federal funding of American higher education, there was, after World War II, a huge increase in public funding, allowing the funding of numerous politically correct and woke departments that otherwise would never have had the money to exist. And public funding means the creation of ideologies, in all cases to some degree. Thirdly, we see that once publicly funded and controlled universities exist, all of their politically correct and woke graduates, year after year, decade after decade, start entering and colonizing all the institutions of society, making them more and more politically correct and woke. Which means, from my point of view, that the vastly increased public funding and control of both public and private education, K-12 and higher in the U.S., since World War II, is also a cause of woke, independently. 4. If all this is true, the question then becomes, how much of a contributing factor is governmental education? What approximate percentage of the total causal mix? In order to get a feel for that, let's do the following thought experiment. Imagine a system of purely private education where all the money that colleges like Hillsdale and Grove City got came from student tuition and philanthropy with no tax exemptions for property or capital gains tax. Now let's imagine that the Civil Rights Act of 1964 is passed and the courts and agencies, like they did, disregard the actual text to make their very own woke law using the disparate impact standard. How then would these purely private colleges respond if the law were enforced by perhaps large fines and the removal of accreditation if colleges didn't follow it? I would argue that they would respond very differently than they have. They would put up much more resistance than they did historically. Since all their money would be coming from the private sector, they wouldn't change their behavior or ideas very much, since otherwise they would lose their students and philanthropic support. Secondly, they simply wouldn't have the money to create all the woke departments in postmodernism and queer and gender theory and hardcore feminism to teach to their students. The money simply wouldn't be there because the private sector, not much liking woke, wouldn't pay for it. Would this not then significantly reduce the number of graduates who were woke and thus the spread of the ideology? And so, if I had to put a number on it, I would say publicly funded education is 2/3 of the mix and the anti-discrimination laws of the Civil Rights Act 1/3. So Richard is partly right. Number 5, one final point about rights violations. If it's true that rights violations create bad culture, then the rights violations which created public education for the century before the Civil Rights Act was even enacted would also play a role in making the country generally more liberal than it otherwise would be. And so we can legitimately ask, would a country that never had any public education have ever had the ludicrous idea that you should try to stamp out racism by the morals legislation parts of the Civil Rights Act? I doubt it. I think an America with no public education ever would have remained much more classically liberal and thus have realized that the best way to get rid of racism is simply through letting racists experience the natural consequences of their behavior in private and public life. Thus, under this scenario, Titles 7 and 9 would likely have never been passed in the first place. So when Richard says long before wokeness was a cultural phenomenon, it was law, I would respond that long before it was law, a publicly funded and controlled education system was law, which tilted the whole country to the left for close to a century gradually. You're not just going to jump from classical liberalism directly to woke, which was why there was a classical liberalism, then liberals, then the politically correct, and then woke. There were at least 4 phases. So having outlined my own approach, let's turn to some final issues. Number 1. What does Richard himself believe about the causal role of publicly funded education? It's not clear. On the one hand, for example, he says the American university provides the most extreme example of what can go wrong when social engineers are given a free hand. That statement blames civil rights law. But then on the other, he also says the university's ideological leanings and financial reliance on the taxpayer mean that they are usually the institutions most welcoming to federal regulation in this area. So are they already, by their public nature in itself, more prone to ideological leanings to the left, as I believe? In any case, whether Richard believes that the public nature of universities are an independent variable in cause, I would argue we can understand the true causation by realizing that both causes are necessary, but neither in itself sufficient to cause the heights of wokeness we've seen. In other words, I'd estimate that with only civil rights law, if you had purely private American education, you would only get 1/3 of the woke result we've seen in the last decade. Number 2, another issue to raise is the degree to which the Civil Rights Act just forces compliance versus causing an actual change in the complied person's beliefs. This is important because pure compliance per se is not really changing the culture, just changing the behavior. We know, for example, as Richard repeats again and again, that almost every time affirmative action has been on the ballot, it has lost. So to what degree are people really just complying and growing to dislike their workplace more and more, so that after a pandemic, all they want is to stay at home? Number 3, we should also ask, are there other ideologies that are created in modern universities because of their public nature, created without the help of specific laws or civil rights laws? If there are, then woke could be created independently as well. And there are. A, the modern anti-Semitism of the left, as we saw after October 7th, with their corresponding Islamophilia. B, the extreme environmentalism, believing in net zero, exhibited by many college students. C, transgender ideology. D, many forms of postmodernism. And E, until the Soviet Union collapsed, socialism and Marxism. All of these ideologies have been created and flourished in modern publicly funded universities without any specific or major law backstopping them or a bureaucracy enforcing them. Number 4. Richard points out that the modern system of student admissions doesn't use an explicit quota system. It's hidden, with Asians trying to get into Harvard being downgraded, unfairly of course, as I mentioned, on their character profile. But the Ivies, or at least Harvard, did the exact same thing to Jews in the 1920s when there was no Civil Rights Act, as Jerome Carable points out in his book, The Chosen. And why was this? Quite possibly because they relied so much on tax-exempt donations, they wanted to keep these funds flowing from their anti-Semitic alumni. 5. Richard seems to downgrade the method of fighting woke by showing why and how its various beliefs are false, like James Lindsay and Gad Saad have done, among others. So while it's true that this method is similar to treating the symptoms of a disease and not the cause, treating the symptoms can be effective medically nonetheless. That's because when enough people realize why woke is bad, because you've explained it to them, or they experience it in a Robin DiAngelo seminar, you eventually get a critical mass of people to oppose it politically. This is exactly one reason why Trump was just elected. The opinion on woke first changed to the negative from about 2020 to 2025, and then Trump was elected and revoked Executive Order 11246. First came the philosophical and cultural change, then the political and legal change. Finally, 6, Richard says, to understand why Russia was communist in 1960, it is more useful to study 1917 in the years immediately after than it is to look at the doctrines of the Russian Orthodox Church and the culture of 18th century peasants. I'd say that to understand why Russia was communist in 1960, you'd want to look at their lower and higher education systems, which was filled with Marxist-Leninist propaganda. In conclusion, this brilliant book by Richard, who understands that rights violations can create bad culture, showcases his great knowledge of American political history since the passage of the Civil Rights Act. His powerful arguments display, time and again, his subtle insights and nuanced observations. I would give it a B+, A-, just taking off slightly because I regard politically funded education as the most important cause of wokeness, with the regulations of the Civil Rights Act being a secondary cause. Aside from that difference, this book is highly recommended for anyone who wants to understand a classically liberal approach to the origins of woke. Very happy for my part that I live in 18th century England, where men thankfully don't go to work in dresses or use women's bathrooms. I bid you well and remain the Scarlet Pimpernel.